I'm Dick O'Mara from the law firm of Murray, Plum & Murray in Portland with Nicole Braddock, who's also from this same law firm. We're here to talk to you today about mediation. First thing you need to know about mediation is that it is one of the three forms of dispute resolution that are allowed under the Individuals with Disabilities Education Act and under Maine's special education regulations. It can be used in various forms, as Nicole will explain, but you need to understand this is one of only three methods, the others being state complaint investigations and due process hearings. Both of those forms are much more formal and involve decisions made by third parties. Mediation, as you will hear, is a decision that's made by the parties to the case, not by a third party. So with that, I'm going to allow Nicole to explain the basics of mediation.
As Dick mentioned, mediation arises in all of the three different types of dispute resolution that are available to you. There's the option to have a standalone mediation, and then there are mediations that are associated with both the complaint investigation process as well as the due process. Mediation generally is an opportunity to negotiate with the other party to settle your claim with the assistance of a neutral third party. Typically the Department of Education, the Maine Department of Education will hire a third party mediator. Sometimes they're attorneys, sometimes they're not, and they will come and assist you and help facilitate the negotiation of a claim. So to discuss generally, you do have the option of a standalone mediation. There are forms that are available on the Maine Department of Education website where you can request a standalone mediation. This is generally what the form looks like, and there is a checkbox here for a standalone mediation. What this means is that you are requesting only to have a mediation and none of the other process that is available to you. So at that time, the Maine Department of Education will hire somebody to facilitate the mediation, and then the mediation will occur. And I can talk to you about. I will talk in a little bit what your options are if the mediation is unsuccessful. But your other option on this same form, it's called the Dispute Resolution Request Form, is a complaint investigation, and below it asks specifically, if requesting a complaint investigation, are you willing to participate in mediation? And then there's a yes or a no. So you can indicate there that you would like mediation in conjunction with your complaint investigation, which we'll talk about in another segment. We'll talk more focused on complaint investigations. And then the last method is in conjunction with the due process hearing request. That is a separate request available from the Maine Department of Education. And again, on this form, it specifically asks, if requesting a hearing, are you willing to participate in mediation? Yes or no. So it is within it's your choice which way you want to go, and we'll talk about which makes more sense depending on your situation. So how does the process work? As I mentioned, the department hires an impartial mediator, and then usually a neutral location is selected. Sometimes the parties can agree to have the mediation at one of the attorney's offices, or other venues can be selected. Typically, all of the parties start in the same room together, and the mediator will begin by explaining the ground rules, confidentiality issues, which we'll discuss in a little bit, and then each party has an opportunity to speak their piece, basically give a review of their position and on why they're there and what they're seeking, and then the other party has the opportunity to do that as well. As far as representation, parties can have attorneys or advocates with them if they would like. The school district can only bring an advocate if the parent brings an advocate under the rules. The school district can only bring an attorney if the parent brings an attorney. If the parent elects to come without any representation, the school district will do so as well. Now, after you have an opportunity to generally talk about your position with the case, the mediator sometimes will then separate the parties, or you can request to separate into different rooms, or you can all stay in the same room together. It really depends on the case. We often find that it's useful to separate the parties so that you can speak more candidly with the mediator. And the mediator will do what essentially is shuttle diplomacy, go back and forth from room to room and try and bring the parties together to come to a resolution. Now, there's absolutely no obligation to come to any sort of agreement with the other party if you're not comfortable, if it's not what you're looking for any reason. There's absolutely no obligation. But if you do come to an agreement and you sign an agreement at that time, that agreement is binding. You would essentially be creating a settlement, a contract with the other party to resolve your claim, which typically involves then dismissing if it's in conjunction with the due process hearing, it typically involves dismissing that hearing or dismissing a complaint investigation if it's in conjunction with a complaint investigation. Oftentimes at the end of mediation, the mediator likes to bring the parties together to just sort of shake hands and try and mend anything that any animosity that may have arisen as a result of the process. The goal is to not have any sort of animosity, but to bring all the parties to the table to sort of shake hands and go on their way. At that time, the mediator will send a notice to the department that the matter has resolved or that it has not resolved, so the state will be aware of what happened as a result of the mediation. You don't have to settle at the mediation, but if the negotiations are moving along, the mediator can suggest to have another follow-up mediation, or the parties can continue to negotiate on their own if they wish. A lot of times that depends on whether or not there are attorneys involved or not. But you can have an agreement sort of in principle and then go and work to finalize the agreement at a later date.
So the basic rules for mediation are that everything that happens in the room is confidential. That's important to know, because you can be free in that setting to take positions, to compromise your position, to suggest deals that might be made without being bound by those deals if you then go on to a complaint investigation or to a due process hearing. That is what is confidential. The facts of the case itself are not confidential. So if you talk about services that were given to your child or actions that were taken by certain staff members, those are the facts of the case. Those are allowed to be talked about if you go on to a different process. But the positions you take, the deals you suggest, the compromises that may be discussed by the parties at mediation, those are confidential. They cannot be used later on, so it's unfair and not allowed to go to hearing and say, well, at mediation they offered me this particular deal. The hearing officer is not allowed to know that, and the hearing officers and the complaint investigators are not allowed to have discussions with the mediators about what the parties said in their dealings at mediation. So the purpose is to try to encourage people to be candid and make a deal. The other thing you need to know about mediation is that, like all of the dispute resolution methods in Maine, it comes with an important right for parents, which is called the stay put right, or the maintenance of placement right. And this means that while the mediation process is going, from the time you file until the time the process ends, there cannot be any change of placement in what's happening with your child. If there's a unilateral change that's been suggested by the school district, and you are opposed to that and state your opposition and ask for mediation, that change cannot go into effect, changing the child's placement, until the process has run its course. It's a very important right, and it's one of the reasons that some parents do ask for mediation after IEP meetings where there's been something suggested with which they don't agree. So at the end of mediation, how does it conclude? As Nicole said, you may reach an agreement. That agreement has to be put in writing, and it has to be signed by both parties. The other way mediation ends is with the parties agreeing to disagree and either moving on to different processes to try to resolve their dispute, or just letting it go back to the status quo and continuing with whatever the decision of the IEP team was. If there's an agreement that is reached at mediation, this is a very important document. You need to be clear that that document states each of the things in which you're agreeing. Don't walk out of the room assuming that things will be done if they're not in writing in that agreement. And this goes for both sides. To the extent that either side is promising to do something, it needs to be in clear writing in that agreement. If you leave it ambiguous, for instance, if it says the child shall receive up to 10 hours of additional service, that means that 5 hours of additional service may satisfy the agreement. So if you're going to get 10 hours of service, make sure it says the child will receive 10 hours of service, not up to 10 hours or words like that. Scan it, make sure that everything seems pretty watertight before you sign it, and then realize that that signed agreement is an enforceable contract. You can either start a complaint investigation with the State Department of Education if it is breached, or you can go to state or federal court and it's enforceable in court, and attorney's fees can be awarded for breaches of mediation agreements. There's a lot of power in that process, so make sure the agreement that you end up with at mediation says everything you want it to say and that there's no ambiguities left in the language. And that should do it for the mediation process. Thank you.